Welcome to the new edition of Judicial Panorama. I am Paramanand Pandey. Today, I will discuss about the first information report, that is to say the FIR, which is an important ingredient of the criminal law. In fact, FIR, as the name suggests, is the first information report which is received at the police station. And if the offence is of a cognizable nature, then the police is bound to register the FIR. There are in fact two types of offences. One is cognizable and other is non-cognizable. Cognizable offences are by nature in fact serious offences, but non-cognizable offences are of not very serious nature. That is why the FIR is lodged only for the cognizable offences, not for the non-cognizable offences. For non-cognizable offences, a daily diary is maintained. A general diary is also called, is maintained at every police station, and those offences are entered into the general diary or the daily diary. And then, if the police thinks it is important, then they will investigate. Otherwise, in fact, it is kept in the record. And the person in fact who is going to inform it to the police station, and if he insists upon the non-cognizable offences, then the police investigates into the matter. Otherwise, it is kept lying there. But FIR, in fact, if it is lodged, if it is of the cognizable offence like murder, like rape, like the attempt to murder, then in that case it is necessary for the police to register it. Police cannot refuse to register the FIR. As far as the non-cognizable offences are concerned, normally it is seen that the police in fact prevaricates. Police does not come forward and lodge the complaint. So, what they do is that instead of lodging the complaint, for instance, if somebody has in fact has got his bag or purse or anything snatched by some of the snatchers, then what happens? Then the police in fact will enter into the general diary and they will refuse to register the FIR. In that case, what happens? They will ask what was there in the bag, what was there in the purse, and if somebody says that mobile phone or wristwatch or anything was lying there and SIM card in fact is not available to me right now, what they will do is that they will enter into the general diary and give it to the person concerned, and in that case the person will go to the department concerned and he or she will get the SIM card on the basis of the general diary report. But in cognizable offences, in fact, the police is bound to investigate the matter. If the investigation is done, the report in fact has to be submitted before the magistrate under section 173 of the CRPC, Criminal Procedure Code. What happens? Normally, in fact, people sometimes give the report and they just try to change it. Then FIR's provision is that it can never be changed, it can never be altered, it can never be amended. Once an FIR has been registered, then it will continue to be the same. Well, if during the investigation, for example, if an attempt to murder has been made by any accused person and ultimately the person dies or succumbs to death, in that case the police will register the case by entering into 302 or the murder. So, that amendment is permissible, but not other things, whatever, because its name is a FIR, first information report. Whatever report has been received at the first instance, that will continue to be the same. But if during the investigation something serious has happened, then it will be added, not changed. That is why it is said that FIR cannot be changed, it cannot be altered, it cannot be amended. A general question, in fact, is normally asked: if FIR has been lodged against anybody and that is a false FIR, in that case what happens? Police cannot change it. Police, in fact, even the highest official of the police will not be able to alter it. The only remedy available for the person is to go to the High Court under section 482 of the Criminal Procedure Code or under article 226 of the Constitution of India. As is known to everybody that under article 226 of the Constitution of India, the High Court has got the enormous power. It will not, in fact, change or cancel or quash the FIR, but if it finds that the real cause of the FIR is not the offense of the person concerned, but in fact, it is a retaliatory measure adopted by somebody just with the bad intentions, then in that case the High Court will quash the FIR. And the other procedure is to approach the Honorable High Court under 482 section of the Criminal Procedure Code. And in that section, if the High Court finds that the FIR is malicious and FIR is vexatious, or if the FIR has been registered just to settle the score with the person concerned and the accused person in fact is not guilty, a prima facie not guilty, then the High Court will be quashing or cancelling that FIR. This is the procedure which is normally adopted in the quashing of the FIR. The other things, in fact, what we find is that the police is, when police starts investigation, then the police will continue to find out the reasons for the crime, and then the police will file the report. What are the essential ingredients of the FIR? While lodging the FIR, the police is bound to know the place where it has been, where the crime has happened. The date or the time of the crime is also recorded by the police, and only on that basis the crime is registered and the police starts investigation. The person, in fact, may give the names of the persons who were seen or committed the crime if he or she knows about it, and if he or she does not know anything about the FIR is the first thing that has to be taken into consideration, and for that purpose the police has to see whether the offense is of cognizable nature or not. The crime's nature is most important thing for the FIR. What was the nature of the crime? That has to be seen by the police, and that will be the basis of lodging the FIR. If the crime is of a very superficial nature or a shallow nature, then the police will not lodge the FIR. It will simply enter it into the general diary. But if it is of the serious nature, then the police is duty bound to lodge the FIR. There are, in fact, many instances when the police have been refusing to lodge the FIR just to show that the crime rate has gone down. But the person who is going to lodge the FIR, he or she will have to be very cautious about it, and he will have to take the copy of the FIR which he has lodged. Then and then he must put his signature on the FIR. The other thing is that if the police is refusing to lodge the FIR, then the person will have to approach the higher authorities and will have to inform that the police, in fact, despite informing that the crime is of serious nature, is not lodging the FIR, then the police official will certainly swing into action, and they will take care of it, the fact that the FIR is lodged. The other important point, in fact, which has to be noted for lodging the FIR is that a person who has been, in fact, getting some sort of information which is not of the trustworthy or by the police, then the police may in fact investigate into the matter prima facie, and then they will lodge the FIR. Because after the lodging the FIR, the police is duty bound to make the investigation. But even before lodging the investigation, a preliminary investigation can be made by the police. These are the very important ingredients of the FIR. These are the facts which must be taken into consideration. The other thing, in fact, what we find is that sometimes the people go and ask the police to change or alter the FIR. That is not possible. Once it has been lodged, it can never be changed. Then the police, the person who is informing it must give the truthful information about the nature of the crime, the time of the crime, the place of the crime, and that will become the basis of the investigation for the police. That will go a long way in solving the case. And the police, once it has lodged the FIR, will have to submit its report within 60 or 90 days, depending on the crime, to the magistrate. The police, in fact, during the investigation has got only one power, that it may foreclose the report. It may say that there is nothing which has been found against the person concerned, against whom the FIR has been lodged, then they can file the foreclosure report. But if there has been something, in fact, which is there, it must be reported to the magistrate. Even while foreclosing the report must be submitted to the magistrate, and the magistrate will decide whether the further investigation is needed or not. If no further investigation is needed, then the crime will start, the trial will start, and crime's trial will start, and then the decision will be taken by the nature of the crime, which depends whether it is triable by some other person or by the sessions judge. That is, in fact, the basic thing which is needed for the FIR. So, friends, today we have discussed about the FIR, which is the most important topic of the criminal law. What more topics should be discussed in the judicial panorama? It will depend upon the suggestions received from you. This topic, in fact, has been dealt because a number of audiences, number of people, they have telephoned me, they have asked me to speak or to say something about the FIR so that they can understand it. What more topic do you suggest to speak on? That will be helpful to me. So, thank you very much for watching this video, and I only request you to share it so that the others may also get the benefit out of it.